The South Platte River and its alluvial aquifer is the scene of a modern-day conundrum. The state legislature wants to know, can we maximize the beneficial use of groundwater while respecting senior surface rights? This brief animation attempts to highlight the events that led us to this place. Before European settlement, the Arapaho and Cheyenne migrated through the South Platte Basin following game. They likely moved on each year when the South Platte's flows disappeared in late summer, and they probably dug into the sandbar aquifers to get cooler and better tasting drinking water. 1860s. Individuals, some of them brought west by the Colorado Gold Rush and the Homestead Act, began growing crops. They dug ditches to divert water directly from the South Platte and its tributaries. In the 1870s, irrigators wanted to irrigate farther from the river, requiring a larger network of ditches. The capital cost was more than one individual could bear. Where did the money come from? Big corporations, some from Europe. One was Travelers Insurance Company. Groups like Greeley's Union Colony, and mutual ditch companies, groups of farmers who got together to pool their resources and labor. 1874. There was an altercation on the Poudre River in which Fort Collins farmers were upbraided by Union Colony farmers because they were taking all the flow of the river. Fort Collins farmers were further upstream, but they didn't get there until after the Union Colony farmers had already dug their ditches. Altercations like this led to the doctrine of prior appropriation. First in time, first in right, regardless of where they are on the river. 1876. Colorado became a state and the doctrine of prior appropriation was written into its constitution. 1890s. Trans Mountain tunnels were dug to bring water from the Grand River and the Laramie River to bolster the flows of the tributaries of the South Platte. This was before the bigger projects, such as CBT and others, did the same thing in the mid-1900s. The first known irrigation well in the South Platte Basin was drilled in 1886. Mr. Hurdle, east of Eaton, used a centrifugal pump powered by a steam engine to help irrigate his farm. 1893. Mr. Hurdle's neighbor, Mr. McClellan, brought suit against him, charging the well pumping was affecting his ability to get his surface water. The court agreed that a well must not be allowed to injure a senior right, but Mr. McClellan still lost his suit because the court said the evidence of injury was too vague. In the 1900s, reservoir construction got underway, a means of storing the spring snowmelt flows because otherwise irrigation for the year would be over by early summer. Reservoirs also opened for irrigation a quantity of land on the lower end of the river that previously could not be irrigated reliably. 1922. Professor Ralph Parshall published a study that showed all the surface irrigation on the South Platte was causing two significant changes: more stream flows in the river and an increase in the groundwater table. 1923. Colorado signed an interstate compact with Nebraska, settling conflict over the use of the waters of the South Platte River. By 1930, 300 high-capacity wells were in operation in the South Platte alluvium. During the 1930s, an estimated 1,400 more high-capacity wells were put into service, many by farmers with surface water rights who recognized that wells supplementing their surface supplies greatly increased reliability, especially during drought. 1940s. Wells really took off in the South Platte Basin because of two developments: the advent of rural electrification and the invention of the turbine pump. W.E. Code, an irrigation engineer with joint appointments with CSU and USDA, pointed out that 80% of the groundwater pumping at that time was being done in conjunction with surface water irrigation. He warned that legislation to strictly limit pumping could harm surface irrigators, to the overall economic detriment of the region. 1950s. Another drought spurred the move towards even more wells being drilled on the South Platte. Drought brought low stream flows. Surface water irrigators and reservoir owners with water rights dating back to the late 1800s and early 1900s began to notice that they didn't have enough water to irrigate, while their neighbors with wells could irrigate. Some became suspicious that wells were drawing water away from the stream. 1956. Ralph Parshall pointed out things that had dramatically changed on the South Platte. He said all the irrigation wells installed in the 30 years since his 1922 study were using up the seepage return flow that earlier had benefited the senior direct flow and reservoir storage rights downstream. 1957. In a response to complaints about wells taking water away from senior surface users, the Colorado State Legislature passed the Colorado Groundwater Law of 1957. This replaced their first attempt at regulating tributary groundwater in 1953. Now you had to get a well permit from the state in order to drill a well, but the permit didn't give you the right to use the water. For that, you had to take your permit along with the evidence of when you first drilled your well, and you could get a water right with that priority date. 1965. The legislature passed the Colorado Groundwater Management Act, which gave the state engineer authority to deny a well permit application if there was no unappropriated water or if the proposed well would injure existing water rights. 1967. The legislature authorized a 2-year study to find out if legislation was needed to bring groundwater into the prior appropriation system. 1968. Mort Bittinger and Ken Wright conducted the study. They found that the South Platte groundwater reservoir contained about 10 million acre-feet of water, but it was being utilized in only a haphazard and unplanned way. They said that the distribution of the water in the aquifer was a problem, not the amount of water. They also found that while groundwater pumping was causing some infringement on senior rights, it was not as severe as some had thought. They pointed out that groundwater pumping was actually helping stabilize water supplies in the South Platte Basin. While it is important to recognize vested water rights on surface diverters, they said, it is also important to efficiently manage the whole water resource, both surface water and groundwater. Also in 1968, the case of Fellhauer versus the People came before the Colorado Supreme Court. It ruled that the state had to come up with orderly rules and regulations regarding groundwater. It couldn't just arbitrarily shut off wells to provide more water for surface users. Justice Groves brought up a new concept. He said that while it is important that we prevent injury to senior water rights, we have to also integrate into the law the concept of maximum beneficial use. 1969. A big year for groundwater in Colorado. The legislature passed an act called the Colorado Water Right Determination and Administration Act. It is often referred to as simply the 1969 Act. In a nutshell, this act said a well user could pump water out of priority, but only if he prevented injury to water right owners senior to him by replacing depletions in time, location, and amount. The means of replacing that water became known as augmentation. The legislation required well users to submit augmentation plans to be adjudicated by the courts. In the 1970s and 80s, well pumpers began to submit augmentation plans. For instance, in 1972, several augmentation plans in the Fort Morgan area were adjudicated, but many others operated under substitute water supply plans that the state engineer allowed. The state's engineer's right to approve these temporary plans was the subject of legislation in 1974 and 1977, and became a major issue, as we will see later. 2 organizations formed to help well users in the South Platte meet the new requirements. One was called GASP, Groundwater Appropriators of the South Platte. The other was formed by the Central Colorado Water Conservancy District on behalf of its members. It was called Central GMS, Groundwater Management Subdistrict. Both of these organizations collected dues from their members and began to find augmentation water. In some cases, they bought permanent supplies, but because it was so expensive, they often leased water from those who had excess. There was an excess of water to lease because these were unusually wet years. During this time, GASP and Central GMS operated under temporary substitute water supply plans. And then, the perfect storm. 2 major events happened to turn things around big time. 2001. The first event was the Empire Lodge case. Water was a side issue in the case, but it led to a Supreme Court ruling that said the state engineer did not have the authority to issue temporary substitute water supply plans indefinitely. Well owners must file for formally adjudicated augmentation plans in order to continue the operation of the wells. 2002. The second event was drought. Big time. The biggest drought since the 1930s. Senior surface water users kept a call on the river almost constantly in 2002, 2003, and 2004, but still received very diminished supplies. GASP and Central GMS couldn't keep up with their members' commitments because the availability of lease water virtually disappeared. The perfect storm created by these 2 events, the major drought and the Empire Lodge case, resulted in tremendous upheaval on the South Platte River. Many who had relied on use of their wells to irrigate crops could no longer do so. The ensuing conflict led to attempts to give relief to well users while protecting the rights of senior surface users. Legislation gave well users additional time to get into compliance, but the lack and expense of available augmentation supplies was a huge detriment to the continued operation of a number of wells. Protests mounted, including a big meeting in 2006 that brought Governor Ritter to Wiggins to listen to angry well users. In 2007, Governor Ritter convened a neutral South Platte Wells task force to listen to testimony and see if they could come up with any solutions. Some testified that senior surface rights must be protected at all costs. Others argued that the level of augmentation required under the new rules was too severe and that shutting off wells was damaging the state's economy. This polarized debate led to little change, but the task force did make 10 recommendations. 2 of the recommendations were eventually adopted: streamlining of the water court to improve efficiency, and forgiveness of current depletions caused by pre-1974 pumping. Now we are in what we would call the full augmentation era. Though approximately 1,200 wells remain partially or fully curtailed for various reasons, many well users have found supplies to fully augment the groundwater use. One way is by purchasing surface water rights to flow into the river directly. Another way is to build recharge projects. These are engineered to deliver water in a manner that replicates the time, place, and volume it would have originally reached the river. A significant number of reports have been made of high groundwater levels causing flooding basements and crop damage. Many believe this to be caused by excessive augmentation of the aquifer and lack of groundwater pumping. Others believe it has more to do with the high water years we have had, or that people are building new structures in areas with naturally high water tables. Some believe the partial augmentation levels achieved between 1974 and 1999 were sufficient to prevent injury and that today's stricter requirements cause over-augmentation. 2012. The state legislature approved HB 1278, funding the Colorado Water Institute at CSU to do a study of the situation. This is the most comprehensive study of the South Platte River Basin authorized by the legislature since the study that led to the 1969 act that brought wells into the prior appropriation system. What does the legislature want this new study to find out? First is the cause of high water tables over augmentation, and if so, what is the remedy? But perhaps more important, what can we learn from the past 45 years since we passed the 1969 act? Is it possible that we could be employing new technologies and knowledge to manage groundwater and surface water in a way that is beneficial to both senior surface users and well pumpers? Are our rules keeping us from using improved operation and management tools that we didn't know about when those rules were passed? Preventing injury to private property rights is critical. But could we meet the dual goals of maximizing the economic beneficial use of the whole water resource while still protecting water rights from injury? December 31st, 2013. The Colorado Water Institute delivered its report to the state legislature. What were their findings? One key finding is that we have reduced pumping in the South Platte Basin by about 50,000 acre-feet, at the same time that we have increased groundwater recharge by over 200,000 acre-feet. These changes were needed to cover pumped depletions as specified by recent court-adjudicated augmentation plans. Not surprisingly, groundwater levels have begun to rise in many of the observation wells across the basin. The concerns expressed about high groundwater in the Greeley and Sterling areas were validated by the groundwater data to be local problems. There are also other areas of the basin where rising groundwater is occurring. Another key finding is that phreatophytes, non-productive vegetation along the river floodplain, continue to increase and take up groundwater that would otherwise flow back to the river. So what did the Colorado Water Institute recommend? They did not recommend more studies. They recommended that pilot projects be set up to try new management techniques in localized areas to deal with high groundwater. They recommended that the state engineer be given additional authority to consult with the water court to alter the management of recharge facilities that are causing localized problems, but in a way that doesn't harm well users or surface water users. They recommended that the state implement the scientifically sound groundwater monitoring plan they developed utilizing existing wells, pulling together the well monitoring efforts of multiple groups across the South Platte Basin. They recommended that the state engineer be directed to develop new rules for the South Platte, with the input of all stakeholders, that could lead to better management of the call regime for all water users. They recommended the need for a new basin-wide entity, for better organization to utilize science and good policy in the conjunctive use and management of surface and groundwater. These and other recommendations and findings can be found at www.cwi.colostate.edu/South Platte/findings.